on Justice Alito's confirmation hearing. When asked about his testimony, Mr. Liu admitted the language was unduly harsh, provocative, unnecessary, and was a case of poor judgment. Now, that's one statement of Mr. Liu's with which I can agree. I can appreciate that Mr. Liu now understands the unfortunate language he uses. The trouble I have with this, however, is that it shows that even when stepping out of the academic world, the nominee promotes extreme views and intemperate language. Even if I accept his rationale for the tone of his work in the academic world, that does not explain his congressional testimony. That was one opportunity where he could demonstrate a reasoned, temperate approach, yet he failed the test. I think it may also indicate that we might expect from Judge Liu, should he be confirmed, the same thing. To me, that's an unacceptable outcome. The fourth major area of concern is Mr. Liu's testimony and candor before the committee, which was troubling at times and lacked credibility. Even before he appeared before the committee, the nominee had difficulty providing the committee with questions, with materials required by his questionnaire. As Senator Sessions said at the time, and I quote, "At best, the nominee's extraordinary disregard for the committee's constitutional role demonstrates incompetence. At worst, it creates an impression that he knowingly attempted to hide his most controversial work from the committee," end of quote. During his testimony, the nominee said in reference to his past legal writings, quote, "Whatever I have written in the books and articles would have no bearing on my actions as a judge." Oh? Trying to paint himself as a judicial conservative, the nominee attempted to walk away from his previous positions. He tried to distance himself on the proper role of a judge, on the use of foreign law, on the appropriateness of racial quotas, and from his previous views on free enterprise and private ownership of property. Even the Washington Post found his testimony a bit hard to believe. The Post editorial stated, quote, "Mr. Liu is unlikely to shun aside completely the ideas and approaches that he has spent years developing, but the real problem, of course, is not that he adheres to a particular judicial philosophy, but that he, like so many others before him, feels he needs to pretend not to have one," end of Post quote. We have often heard the term confirmation conversion applied to nominees who appear to have a change of legal philosophy when they're nominated to the federal judgeship. As I review the record, I think this nominee has taken that concept a step further, and I would use the phrase confirmation chameleon. It seems to me that Mr. Liu is willing to adapt his testimony to what he thinks is most appropriate at the time. I've discussed other contradictions already, but let me give you a clear example. Senator Cornyn of Texas asked him about his troubling record contained in his work product that expressed opinions on issues such as the death penalty, same-sex marriage, and welfare rights. Senator Cornyn then stated, quote, "You're now saying wipe the slate clean because none of that has any relevance whatsoever to how I would conduct myself as a judge if confirmed by the Senate. Is that correct?" End of quote from Senator Cornyn. And Mr. Liu responded, quote, unquote, "That is correct, Senator." A few minutes later, I asked him if he were, quote, this is my quote, "If we were to, let us just say, wipe the slate clean as to your academic writings and career, what is left to justify your confirmation?" The nominee responded, quote, "I would hope that you would not wipe my slate clean, as it were. You know, I am what I am." End of quote. Mr. Liu cannot have it both ways. Either his record stays with him or we wipe the slate clean. Perhaps in the long run it doesn't matter, because either way it leaves us with an individual who should not be given a lifetime appointment. If you include his record as a law professor, then we're left with evidence of left-leaning judicial activism. If you do not include it, then we're left with a 2-year associate with law clerk experience and little else. That leads me to my final point. I'm concerned about the nominee's lack of experience. After graduating from law school in '98, he clerked for Judge David S. Tatel on the U.S. Court of Appeals, D.C. When his clerkship ended, Mr. Liu became Special Assistant Deputy Secretary of Education for 1 year. In 2000, he worked as a contract attorney for a law firm, Nixon Peabody, LLP, where he, quote, assisted with legal research and writing, end of quote. From 2000 to 2001, the nominee clerked for Justice Ruth Bader Ginsburg on the Supreme Court. After that clerkship, he became an associate at O'Melveny and Myers, where he remained for less than 2 years. According to his questionnaire, he appeared in court only, quote-unquote, occasionally. He also reported that his other work as an attorney has not involved court appearances. He has not tried any cases to verdict, judgment, or final decision. Since 2003, the nominee has been a full-time law professor at UC Berkeley School of Law, and in 2008 he became Associate Dean. After his nomination last year, the ABA Standing Committee of the Federal Judiciary gave Mr. Liu the rating of unanimous, well qualified. I'm somewhat perplexed by this rating. According to the Standing Committee's explanation of its standard for rating judicial nominees, quote, a prospective nominee to the federal bench ordinarily should have at least 12 years' experience in the practice of law, end of quote. Further, quote, the committee recognizes that substantial courtroom and trial experience as a lawyer and trial judge is important, end of quote. At the time of his nomination and rating, the nominee had graduated from law school less than 12 years prior. He's been a member of the State Bar only since May '99. As noted above, he has no trial experience, has never been a judge. So, I want to conclude with this thought. Given his record and testimony, I do not believe the nominee has an understanding and appreciation of the proper role of a judge. I believe if confirmed, he will bring a personal agenda and political ideology into the courtroom. It is ironic that in commenting on Roberts' nomination, Mr. Liu said, quote, the nomination is a seismic event that threatens to deepen the nation's red-blue divide. Instead of choosing a consensus candidate, the President has opted for a conservative thoroughbred who, if confirmed, will likely swing the court sharply to the right on many critical issues. If confirmed, I'm concerned that Mr. Liu will deeply divide the Ninth Circuit and move the court even further to the left, if that's possible. If confirmed, his activist ideology and judicial philosophy would seep well beyond the Berkeley campus, and that seems like that's difficult. Sitting on the Ninth Circuit, his opinion and rulings would have far-reaching effect on individuals and businesses throughout the 9-state circuit, including places like Bozeman, Montana, Boise, Idaho, and Anchorage, Alaska. For the reasons I have articulated, 1, his controversial writings and speeches, 2, an activist judicial philosophy, 3, his lack of judicial temperament, 4, his lack of candor before the committee, and 5, his limited experience, as well as many other concerns which I have not expressed today. I shall oppose this nomination, and I yield the floor.
Mr. President.
The Senator from California.
Mr. President, I ask unanimous consent that I might be permitted to speak for 1/2 hour.
Without objection.
Thank you very much, Mr. President. I've been on the Judiciary Committee for 18 years. I have never heard a harsher statement about a brilliant young man than I have just heard. And during those 18 years, I've seen the standards for appointment change rather dramatically. I've seen a search engine develop on the Republican side to go out and find anything and everything an individual may have written and then compile a dossier almost like you would of a criminal, and then characterize and depict the individual in the terms that you wish to do. I really regret this, and I hope to lay out how the Democratic side with a number of nominees, has not done the same thing. But to see a young man with the credentials that Goodwin Liu carries really belittled in the way in which he has been belittled in these hearings and also on this floor really, really upsets me. This man is a professor of law and the former associate dean of one of the 10 best law schools in America. He's a nationally recognized constitutional scholar. He is a truly brilliant legal mind. I have every confidence in his intellectual firepower, his integrity, and his even-keeled demeanor, and believe it will make him a fine judge. Let me tell you a little about his background. He was born in Augusta, Georgia. He's the son of Taiwanese immigrants who were recruited to America to provide medical services in rural areas. He attended public schools in Clewiston, Florida, in Sacramento, California. He first struggled to learn English and master vocabulary, but ultimately he graduated co valedictorian from Rio Americano High School in Sacramento. He was admitted to Stanford University, my alma mater. He graduated Phi Beta Kappa. He received numerous awards for his contributions to the university, and he was elected co-president of the student body. Pretty good. He received a Rhodes Scholarship. He graduated with a master's degree from Oxford University. He attended Yale Law School. Once again, he was at the top of his class. He was editor of the Yale Law Journal. He won the prize for the best team argument in the moot court competition and won awards for the best academic paper by a third-year student and the best paper in the field of tax law. He received prestigious judicial clerkships with Circuit Judge David Tatel of the United States District Court of Appeals for the District Circuit, and then with Ruth Bader Ginsburg on the United States Supreme Court. He worked in the Department of Education as a special assistant to the Deputy Secretary at the United States Department of Education. He spent the 2 years in O'Melveny & Myers, which is a prestigious law firm, not a minor firm, a major firm, where he handled commercial matters, antitrust, insurance, class action cases. Appellate law comprised roughly half of his practice. And finally, in 2003, he accepted a tenure-track position on the faculty of Boalt Hall School of Law. At Boalt, he quickly established himself as one of our most astute legal scholars, with specialties in constitutional law, the Supreme Court, and education law and education policy. He published articles in the Yale Law Review, the Stanford Law Review, the California Law Review, the Iowa Law Review, the Harvard Law and Policy Review, and many other academic journals. He received the Education Law Association's Stephen Goldberg Award for Distinguished Scholarship in Education Law, and he was elected into membership of the American Law Institute. In 2008, his colleagues on the faculty at Boalt selected him as their Associate Dean. And in 2009, the University of California at Berkeley awarded him their Distinguished Teaching Award, the highest award for teaching across the entire university. Now, I believe he holds a deep appreciation for what opportunities our country affords. I believe his background and his legal prowess are fitting for him to become an appellate court judge. And when you speak with him about his family and upbringing, you gain a sense of him as someone who loves this country and bears an abiding belief that ours is a land of opportunity and a place where everyone has a chance to learn and grow and to thrive. My colleagues, some of them, have questioned a number of his writings and his temperament. And what figures very formidably, as I've talked to the Republican side, was particularly testimony that he gave on the confirmation of Justice Alito. And what he did was provide a long analysis of Alito's opinions, and then at the end he used a rhetorical flourish that was quite frankly misguided. He strung together a series of facts from cases Alito had decided, and then made a statement that I believe he very much regrets. It was over the top, but he has acknowledged it. He has been forthright, and he has apologized. Before the Senate Judiciary Committee, he said, and I quote, "What troubles me most is that the passage had an ad hominem quality that is unfair and hurtful. I regret having written this passage." He said if he had to do it again, I would have deleted it. It was a mistake, no question about it. But a mistake should not color this man's entire record. I want you to read from two letters that we've received in the Senate from people who knew and know Goodwin Liu well, not just for a moment, but for years. The first was sent to us jointly by 3 successive presidents of Stanford University, and I've never seen a letter on behalf of a nominee from 3 different presidents of a university of the quality of Stanford. Donald Kennedy was president when Goodwin Liu was a student at Stanford. He worked with Liu at the Haas Center for Public Service and was present when Liu won not only the Dinkelspiel Award, which is the university's highest award for undergraduate service, but also the James W. Lyons Dean Award for Service and the President's Award for Academic Excellence. Gerhard Casper is President Emeritus of Stanford and currently Provost of the University of Chicago. He knows Liu both as a Stanford alum and also as a colleague in the field of constitutional law. He is familiar with Liu, as, in his own words, he calls, quote, a measured interpreter of the Constitution. And finally, John Hennessy is Stanford's current president. He describes Liu as insightful, hardworking, collegial, and the highest ethical standards. So today, these 3 presidents of the university wrote the following. Goodwin Liu, as a student, scholar, and trustee, has epitomized the goal of Stanford's founders, which was to promote the public welfare by exercising an influence on behalf of humanity and civilization, teaching the blessings of liberty, regulated by law, and inculcating love and reverence for the great principles of government as derived from the inalienable rights of man to life, liberty, and the pursuit of happiness. It is fitting, and I believe an accurate tribute. We have one of the most brilliant scholars, legal scholars of our time, and unfortunately, there's a majority here to confirm him. We know that. But unfortunately, the minority is going to use cloture to prevent us from ever casting a vote to confirm him. Let me turn to another letter. This one is from 8 top executives of major American companies, including Yahoo, General Atlantic, Morgan Stanley, and Google. They've all worked closely with Liu on the Stanford Board of Trustees, and they wrote to say the following. Even in a room full of highly accomplished leaders, Goodwin is impressive. He is insightful, constructive, and a good listener. Moreover, he possesses a remarkably even temperament. His demeanor is unfailingly respectful and open-minded, never dogmatic or flexible. Goodwin's strengths, they say, quote, are exactly what we expect in a judge: objectivity, independence, respect for differing views, sound judgment, end quote. We know the American Bar Association has unanimously rated him well qualified for the United States Court of Appeals, and his background is similar to many who have been confirmed to the Circuit Court in the past. But some on the other side, nevertheless, he's too young and he doesn't have judicial experience or his credentials are not right. For those who asked for a judicial record to review, I would ask, what about Edward Chen? We considered Judge Chen's nomination last week. He was a district court nominee with a 10-year judicial record. He had written more than 350 published opinions, and the minority didn't criticize one. But most in the minority voted against his nomination anyway. So a judicial record doesn't get it done. Then there are the criticism based on age or other qualifications. But Liu's qualifications surpass those of many we have confirmed under Republican presidents. Since 1980, the Senate has confirmed 14 circuit court nominees who were under the age of 40. That means they were all younger than Liu is now. All 14 were nominated and confirmed during Republican administrations. Let me give you two examples. Judge Kimberly Moore sits on the United States Courts of Appeals for the Federal District. She was nominated by President Bush at the age of 38. She had 2 years of experience as a law clerk, less than 4 years in private practice, and 6 years as a professor at 3 different law schools. The Senate confirmed her unanimously. Judge Harvie Wilkinson is a judge on the United States Court of Appeals for the Fourth Circuit. He was nominated by President Reagan at the age of 39. He had 1 year experience as a law clerk, 3 years as a newspaper editor, 1 year of government practice, and 5 years as a professor. He was confirmed. Judge Brett Kavanaugh, who now sits on the United States Courts of Appeal for the D.C. Circuit, also comes to mind. He was 38 when he was nominated. Unlike Liu, he had little track record to review, and much of the record that did exist was partisan. He had been a law clerk for 3 years, spent 3 years in private practice, and spent the remainder of his career in the Solicitor General's office, Ken Starr's Office of Independent Counsel, and the Bush White House. When the ABA conducted its reviews, many troubling reports were received. But I voted for cloture, as did my colleagues on this side, and he was confirmed. Professors are hardly a new game for us when it comes to judicial nominees. John Rogers is a judge on the United States Court of Appeals for the Sixth Circuit. At the time that President Bush nominated him, he had only 4 years of practice experience, no appellate clerkships, and has spent the remainder of his career as a professor. He was confirmed by the Senate by a voice vote. And finally, there is Michael McConnell from the state of Utah. President Bush nominated Professor McConnell for the 10th Circuit. At the time, he had been a constitutional law professor for 16 years, and his writings contain scores of controversial thoughts, ideas, and provocations. In reviewing McConnell's record, many of us on the Democratic side found writing after writing that we strongly disagreed with. McConnell had repeatedly stated that Roe v. Wade was wrongly decided. He called the Supreme Court decision, quote, a grave legal error, end quote, and, quote, an embarrassment, end quote. He wrote that the Freedom of Access to Clinic Entrances Act and the Violence Against Women Act were unconstitutional. He criticized a Supreme Court decision barring racial discrimination at tax-exempt schools and one prohibiting sex discrimination in civic associations. And he called the fundamental guarantee of one person, one vote wrong in principle. But like Professor Liu, he made clear in the Senate confirmation process that he understood the difference between the role of a professor and the role of a judge. Here's what he said when asked about all of his writings. I had a whole bunch of writings out there that were provocative and innovative and taking a different view. Well, within my academic colleagues, they understand that that's what we do. If you try to make those look as though they are legal analysis, as if they were what a lawyer thinks the law is. Of course they don't reflect the law. They're not meant to. They're not a description of the law. Professor Michael McConnell, Senate Judiciary Committee, September 18, 2002. He then assured us that he would apply the law as written, not as put forward in academic theory. And guess what? He was confirmed to the 10th Circuit by unanimous consent. There was no cloture vote. He was confirmed by unanimous consent because the Democrats on this side of the aisle believed that he would do just what he said. I don't understand why this same situation is not accorded to this brilliant young American. So today we have Professor Liu before us. He's also written article after article as a law professor, and people have disagreed with some of what he's written. And here is what he said. I think there's a clear difference between what things people write as scholars and how one would approach the role of a judge. And those two are very different things. As scholars, we're paid in a sense to question the boundaries of the law, to raise new theories, to be provocative in ways that it's simply not the role of a judge to be. The role of a judge is to faithfully follow the law as it is written and as it is given by the Supreme Court. And there is no room for invention or creation of new theories. That's simply not the role of the judge. A very similar statement. It was made by Goodwin Liu before the Senate Judiciary Committee, April 16, 2010. He went through by unanimous consent. Same kind of situation, unanimous consent. And yet, we may be prevented from even taking a vote on the nomination because he will not get a supermajority for cloture. I must say, what's sauce for the goose is sauce for the gander. Professor Liu, like Professor McConnell, is a brilliant legal mind. He has written extensively. He's been absolutely clear that if confirmed, he would follow not any academic theory or writing, but the law as it is written and handed down by the United States Supreme Court. We took Professor McConnell at his word. Professor Liu deserves the same treatment. And what's interesting to me, how much things have changed on this committee, and we have a new presiding officer who also is on the committee, since before you, Mr. President, came on, when we would really look at a person's personal record, what they've said, what they think the kind of judge they will be, and make a decision. So I don't understand. If we can confirm Professor McConnell by unanimous consent, why can't we grant cloture to a man that has distinguished himself as one of the great legal scholars of our country? Let me address one particular criticism that has been made of Professor Liu's writings, and that's the writing on constitutional interpretation and fidelity to the Constitution. Some in the Senate have harshly criticized his book, Keeping Faith with the Constitution, because he says at one point that the Supreme Court has taken social practices, this is a quote, social practices, evolving norms, and practical consequences into account when interpreting the Constitution. This, some colleagues say, means he will be an activist. First, Liu has said this book was written as a professor, as an academic, that it is in no way a roadmap for how he would decide cases as a judge. He said in his own words, the duty, and this is a quote, of a circuit judge is to faithfully follow the Supreme Court's instructions. on matters of constitutional interpretation, not any particular theory. And so that is exactly what I would do. I would apply the applicable precedents to the facts of each case, end quote. But I think that some are using this nomination to try to set a new standard, to say that the only valid theory of constitutional interpretation is originalism. So I want to point out that Lou's comments about constitutional interpretation are hardly exceptional. In fact, they echo statements made by some of our very best jurists across the span of American history. Chief Justice John Marshall, Justice Oliver Wendell Holmes, and Justice Sandra Day O'Connor, to name a few. The most famous example, Chief Justice John Marshall wrote in 1819 in the case of McCulloch v. Maryland, and I quote, "We must never forget that it is a Constitution we are expounding. This provision is made in a Constitution intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs," end quote. Chief Justice John Marshall. We're not all originalists here, and originalism does not define the legal mainstream. In an interview published in the California Lawyer in January, Justice Scalia made the shocking statement that he does not believe the United States Constitution guarantees women equal protection of the law. This came out this January. This is a sitting Supreme Court justice saying the Constitution does not guarantee women equal protection under the law. Now, the text of the 14th Amendment says no person shall be denied of equal protection of the law, and after decades of precedent, unanimous Supreme Court decisions agree that women are protected. But regardless of text and precedent, Justice Scalia says it can't be so, because that's not what the drafters of the 14th Amendment intended. This is not the American mainstream. Following this line of reasoning, the minimum wage would be unconstitutional. Schools could still be legally segregated. States could prohibit married couples from using birth control. And I, as a woman, could be prohibited from standing here today as an elected member of the United States Senate. That kind of thinking cannot be a criterion for acceptance onto our federal courts. So some may disagree with Lou's statement about constitutional interpretation, but it is hardly a field of the legal mainstream today. Let me just tell you what others who are familiar with Lou's full record, have said about its work. Richard Painter, the chief ethics officer for President George W. Bush, relayed similar thoughts after reviewing Lou's record. Here's a quote. "Lou's views are part of the legal mainstream, and the intended independence, rigor, and fair-mindedness of his writings support a confident prediction that he will be a dutiful and impartial judge. Lou respects the law, which is what we should begin to expect of a judge. And yet the United States Senate may well not give him cloture even to come to a vote on his confirmation. Mr. President, that is unfair." Jesse Chopin, who reviewed all of Lou's writings as the chair of his tenure committee, has similarly said, "In addressing a wide range of issues, Lou demonstrates rigor, independence, fair-mindedness, and most importantly, for present purposes, sincere respect for the proper role of courts in a constitutional democracy. One thing is clear," he says, "Lou's interpretive approach is part of mainstream legal thought," end quote. And finally, someone who's been quoted often here today, Kenneth Starr, a prominent conservative, former Reagan appointment to the D.C. Court of Appeals, has written to us together with Professor Akhil Umar to say, and I quote, "Goodwin Liu is a person of great intellect, accomplishment, integrity, and he's exceptionally well qualified to serve on the Court of Appeals. In our view," he goes on, "the traits that should weigh most heavily in the evaluation of an extraordinarily qualified nominee such as Goodwin are professional integrity and the ability to discharge faithfully an abiding duty to follow the law. Because Goodwin possesses these qualities to the highest degree, we are confident that he will serve on the Court of Appeals not only fairly and competently, but with great distinction." I have a very hard time understanding why people would do this, where we listen to and read Appellate Court Judge McConnell's views, which were antithetical to many of us on this side, but believed he would be a fair and good judge, and he was unanimously confirmed. And someone who has the finest education America has to offer, is supported by scholars on both sides of the political aisle, who is truly scholastically exceptional, who could quote case after case after case in his hearings, may well be denied cloture. If he is, this is not the Senate of the United States, of which I am most proud. I hope I'm wrong. I hope he will be granted cloture, because he deserves a vote, up or down, majority. That's America, majority vote on his confirmation. We'll see what happens. I thank the chair. I yield the floor. Mr. President, I note the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.